Understanding the Onshore Partner Visa, Subclass 820, who can apply? The Subclass 820 visa is a very important step for partners wishing to build a life together in Australia. This visa is an onshore visa, meaning you must be physically present in Australia when you submit your application. The 820 visa is a temporary visa, allowing you to live, work, and study in Australia, while the Department of Home Affairs processes your application for a permanent partner visa, which is the Subclass 801. This visa is specifically designed for individuals who are already in Australia, perhaps on a different type of visa, and want to remain with their Australian partner without needing to depart the country. This pathway provides considerable stability and peace of mind during the often lengthy processing times. This visa is intended for individuals who are either married to or in a de facto relationship with their sponsoring partner. The sponsoring partner must be an Australian citizen, an Australian permanent resident, or an eligible New Zealand citizen. A de facto relationship is generally understood as a relationship where you and your partner live together as if you were married, but you are not legally married to each other. For the purpose of this visa, this de facto relationship typically needs to have existed for at least 12 months immediately before you lodge your application. However, it is important to know that there can be certain exceptions to this 12-month requirement, such as if your relationship is officially registered with an Australian state or territory government. The onshore aspect of the Subclass 820 visa is a critical detail that applicants must understand clearly. You are required to be physically within Australia's borders at the time you lodge your visa application. Furthermore, in most cases, you will also need to be in Australia when the department makes a decision and grants your temporary visa. This is a key difference from offshore partner visas, where the applicant is typically outside Australia throughout the process. A significant benefit of applying onshore is that you may be granted a bridging visa. This bridging visa usually activates when your current substantive visa expires, allowing you to remain lawfully in Australia while you await the outcome of your 820 visa application. The Australian partner visa process is generally structured as a two-stage journey. When you apply for the temporary Subclass 820 visa, you are, in most circumstances, also simultaneously applying for the permanent Subclass 801 visa. This is usually covered by a single application charge. The Department of Home Affairs will first assess your eligibility for the temporary 820 visa. If this temporary visa is granted, you will then usually be assessed for the permanent 801 visa approximately 2 years after the date you initially lodged your combined application. This later assessment is contingent on your relationship still being genuine, continuing, and meeting all other requirements. This two-step approach allows the department to confirm the ongoing and committed nature of your relationship over a significant period. Meeting the mark eligibility for you and your partner. As the person applying for the visa, you carry the responsibility of demonstrating that you are in a genuine and continuing relationship with your sponsoring partner. This is the cornerstone of your application. Beyond the relationship itself, you must also meet specific health requirements. This usually involves undergoing a comprehensive medical examination conducted by a doctor approved by the Australian government, known as a panel physician. Furthermore, you must satisfy strict character requirements. This is typically proven by providing police clearance certificates from every country where you have lived for a total of 12 months or more during the last 10 years, since turning 16 years of age. Any past visa cancellations or application refusals could potentially affect your eligibility, so complete honesty is crucial. You generally must also hold a valid substantive visa or a specific type of bridging visa when you apply. Your sponsoring partner also has a set of crucial eligibility criteria that they must meet for your application to be successful. The sponsor must be an Australian citizen, an Australian permanent resident, or an eligible New Zealand citizen. They must generally be at least 18 years old. Critically, the sponsor cannot have certain criminal convictions on their record, particularly those relating to offences against children or violent crimes, which could disqualify them from sponsoring. There are also limitations on how many partners a person can sponsor in their lifetime. and how recently they may have sponsored another partner, or, indeed, been sponsored themselves as a partner. The sponsor must also formally agree to provide financial support and accommodation for you, the applicant, during your initial 2 years in Australia. The absolute core of your partner visa application is proving that your relationship is both genuine and continuing. You must be able to show the Department of Home Affairs that you and your partner share a mutual commitment to a shared life together, and that this commitment is to the exclusion of all other romantic partners. This means your relationship must be exclusive. You must either be legally married to your partner, or you must be living together in a de facto relationship. If you are not currently living together, you must demonstrate that any separation is only temporary and that you maintain your commitment. The department will carefully examine various aspects of your relationship to assess its authenticity. So, providing comprehensive and consistent evidence across all facets is absolutely vital. For de facto partners, the general rule states that your relationship must have existed for a minimum of 12 months immediately before you lodge your visa application. This 12-month period is typically counted from the date you and your partner commenced living together as a couple, sharing domestic and financial aspects of your lives. However, this specific requirement can sometimes be waived. For example, if your de facto relationship is officially registered with an Australian state or territory government that offers such a registration scheme, the 12-month minimum cohabitation period may not apply. It might also be waived if there are compelling and compassionate circumstances, such as having a dependent child from your relationship. If you are married, your marriage must be legally valid and recognised under Australian law. Gathering your proof, essential documents and relationship evidence. A successful subclass 820 visa application relies heavily on providing thorough and credible documentation. Both you, the applicant, and your sponsoring partner must provide certified copies of key identity documents. These include your current passports, full birth certificates showing parents' details, and any official documents relating to name changes, such as marriage certificates or deed polls. Your sponsor will also need to provide solid evidence of their Australian citizenship, such as an Australian passport or birth certificate, Australian permanent residency status, or their status as an eligible New Zealand citizen. You will also need to prepare for health examinations and gather necessary police clearance certificates from all countries where you have resided for significant periods. Furthermore, at least 2 statutory declarations, known as Form 888, from Australian citizens or permanent residents who know both of you and can personally attest to the genuine nature of your relationship are typically required. Demonstrating the financial aspects of your relationship is an absolutely crucial component of your evidence. You need to provide clear proof of how you and your partner share financial responsibilities and pool your resources as a couple. This can include submitting joint bank account statements that show shared income and expenditure over a considerable period. Evidence of regular financial support or transfers between your individual accounts can also be useful. Proof of any joint ownership of major assets, such as a house, a car, or significant investments, is very strong evidence. Shared bills for essential utilities like electricity, gas, or water, as well as joint lease agreements or mortgage documents in both names, also powerfully support your claim of a shared financial life. The nature of your household and how you conduct your social life together provides further substantial proof of your ongoing relationship. Evidence of your shared living arrangements is very important. This can include a joint tenancy agreement for a rental property or mortgage documents if you own a home together. If you live with other people, such as family or housemates, you should explain these arrangements clearly. You can show how you share household responsibilities through written statements or even a shared domestic roster. Mail that has been addressed to both of you at the same residential address, either jointly or individually over time, is also very helpful. Socially, you should include a good selection of photographs taken together throughout your relationship, especially those that include family members and mutual friends. Invitations to events addressed to you as a couple, joint travel itineraries and bookings, and even evidence from social media platforms showing your public recognition as a couple can be submitted to strengthen your application. You must also clearly demonstrate the mutual commitment that exists between you and your partner, and show how your relationship has developed and strengthened over time. This includes providing evidence that you both have a deep knowledge of each other's personal circumstances, such as details about family backgrounds, important life events, and future aspirations. Evidence of your shared intention to have a long-term, committed life together is absolutely key. This can often be best shown through detailed personal written statements from both of you, outlining the history of your relationship, how you met, significant milestones you have shared, your feelings for each other, periods of cohabitation, and your concrete plans for the future. Any correspondence between you, especially during any periods of separation, such as emails, chat logs, or phone records, can also effectively support this aspect of your relationship. Navigating the maze costs, complexities, and expert help from BMS Global. Applying for an Australian partner visa, such as the SUBCLASS 820, invariably involves significant financial planning and consideration. The primary cost is the visa application charge, which is payable directly to the Department of Home Affairs at the time of lodging your application. This fee is substantial and is subject to change, often annually, so it is absolutely vital to check the latest fee schedule on the department's official website before you submit your application to avoid any errors. Beyond this main visa application charge, there are several other potential expenses that you should budget for. These can include fees for undertaking the required medical examinations with approved panel physicians, costs associated with obtaining police clearance certificates from various countries, and fees for the professional translation of any documents that are not in English by NATI accredited translators. Planning for these costs up front is a very important part of the application process. Australian immigration law is widely recognised as being exceptionally complex, and it is also subject to frequent amendments and policy updates. The specific legislative criteria for partner visas are highly detailed and often require careful interpretation to ensure full compliance. Even seemingly minor mistakes or omissions in your application form or within your supporting documentation can unfortunately lead to considerable processing delays or, in the most regrettable circumstances, an outright visa refusal. Understanding the nuances of what constitutes sufficient evidence to prove a genuine and continuing relationship can be particularly challenging for applicants who are attempting to navigate this intricate system on their own without professional guidance. The legal requirements are undeniably stringent, and the Department of Home Affairs meticulously scrutinises every application submitted. The high personal stakes involved make accuracy, completeness, and attention to detail absolutely paramount. This is precisely where the specialised expertise of registered migration agents, such as the professionals at BMS Global, becomes truly invaluable. BMS Global has a dedicated team specialising in Australian immigration law, with a strong focus on complex partner visa applications like the SUBCLASS 820 and 801. Their experienced migration consultants can significantly simplify the entire complex process for you, providing clear, understandable, and tailored guidance every step of the way. They will help you thoroughly understand the specific legislative requirements relevant to your unique personal situation. They assist in meticulously preparing a comprehensive and decision-ready application, ensuring all necessary evidence is included and presented in the most effective manner to the department. This professional support can substantially reduce your stress levels and greatly increase your chances of achieving a successful visa outcome. BMS Global ensures they are always up to date with the latest legislative changes. If you are currently considering applying for the Onshore Partner Visa Subclass 820, attempting to navigate the multifaceted requirements and potential pitfalls alone can be an incredibly daunting and overwhelming task. We strongly encourage you to seek professional assistance to ensure your application is as strong as possible and has the best possible chance of success. The dedicated team at BMS Global is committed to helping partners like you achieve their dream of living together permanently in Australia. They offer personalised consultations to thoroughly assess your eligibility and to provide expert guidance throughout the entire application journey, from initial preparation to the final decision. You can contact BMS Global today for trustworthy and expert advice by calling them on 1800 123 456 or by visiting their website at www.bmsglobalaustralia.com.au. Let the experienced professionals at BMS Global help you confidently take this important step towards building your future together in Australia.